Has every member voted? Has every member voted? If so, the clerk close machine, ascertain the results. On this question, 32 yeas, 0 nays, 2 absent, not voting. More than a majority of those present voting having voted in the affirmative, I declare the bill passed. The clerk has a title amendment.
Committee on the Judiciary move to amend the title of the bill.
Question is on adoption of the title amendment. All those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the title amendment adopted. The clerk will communicate the actions. Senate will be at ease for a moment. We're trying to determine the effective date. Senior Senator from the 17th.
Thank you, Mr. President. I move the bill be made effective from passage. Thank you, Mr. President. I move the bill be made effective from passage and request unanimous consent that the roll call used on passage of the bill be used to make it so effective.
Senior Senator from the 17th moves that the bill be made effective from passage and use the roll call on the passage of the bill to make it so effective. Is there objection? Chair hears none. On this question, 32 yeas, 0 nays, 2 absent, not voting. More than 2/3 of those elected to the Senate having voted in the affirmative, I declare the bill effective from passage. The clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for House Bill 3270 to amend the deliberate intent statute to limit non-economic damages to $500,000. Third reading of the bill.
Question is on passage of the bill. Senator from Morgan.
Thank you, Mr. President. The bill amends two sections in the state code, and they're both in Chapter 23. That's the workers' comp chapter. Both in Article 4, and it amends one section, Article 2, and it adds a new section, Article 2A. This is House Bill 3270. West Virginia employers who are covered under workers' comp, that system, enjoy, generally speaking, immunity from employee lawsuits for workplace injuries. That is the historical trade-off made by the Workers' Compensation Act. An employee doesn't have to prove that his employer was negligent in any way. If the rule is the employers get immunity from suit, the employees get workers' comp. And they don't have to prove negligence. They just have to prove generally a workplace injury to be eligible for workers' compensation benefits. An employer, however, under our current law may lose that immunity under what is known as a deliberate intent lawsuit, and that's sometimes referred to as a Mandelitis claim. That's a case from, I think, the late 70s in which our Supreme Court allowed a suit for recovery over and above workers' comp benefits for an employee injured through the deliberate intent of his or her employer. So by statute, an injured employee can bypass an employer's workers' compensation immunity and bring a civil action against the employer by establishing that the injury was caused by an employer deliberately exposing the employee to unsafe working conditions, and there's a 5-part test in our code that has to be met. This bill addresses that specific species or class of cases. The committee substitute from the House addresses two aspects of this. The first part addresses deliberate intent cases that are based on an employee suffering from occupational pneumoconiosis. That is black lung, white lung for people that have silicosis, but it's a respiratory disease that comes from long-time exposure to minute particles of dust in the air, and it's a horrible disease. Over time, it takes the ability of a person's lungs to process oxygen, which we all need to live. In those cases, the employee is required to prove the 5-part test, just like any other deliberate intent case, but under the bill would be required to prove that the employer concealed or manipulated dust samples or air quality samples to be successful in prosecuting a deliberate intent claim. With respect to damages in all deliberate intent claims now, there is a cap in this bill placed upon non-economic damages. And the cap would be the higher of 2 times the economic damages or $500,000. And that is like our medical malpractice cap. That $500,000 cap is indexed. It's indexed to a consumer price. It's actually the consumer price index and would increase to account for inflation. The cap would not apply to causes of action accruing. The cap would apply only to causes of action accruing after July 1st of this year. Mr. President, be happy to try to answer questions. Otherwise, I urge passage of the bill.
Question is on passage of the bill. Is there discussion? If Senator from Marion.
Thank you, Mr. President. I rise in opposition to House Bill 3270. I just don't know where we come up with a number of $500,000 to put on a life. That just bothers me where that, that number just popped out of the sky. And, let's talk about the deliberate intent legislation or the law that we have in place right now. I think we revisited this in 2015, and it became much, much harder to prove deliberate intent. Much, much harder. If you listen to the chairman, there's a 5-point test that you have to go through before you can even bring a cause of action. One is that they have to intentionally expose an employee to a specific unsafe working condition. And then that employee must have suffered a serious compensable injury or compensable death. And 2 other ones, Mr. President, an unsafe working condition must have existed in the workplace. And the employer must have had actual knowledge of the existence. And it was a violation of state or federal law or safety statute, whether it was cited or not. And beyond all of that, you had to have at least a 13% compensable injury. So if you lost a couple fingers, you wouldn't even qualify. And in committee, Mr. President, there was testimony that since the legislation passed in 2015, claims have come down by 76%. 76% claims have come down. And premiums have been reduced by about 50%. So I'm not sure why we got to do this. And then all of a sudden this proviso comes into play dealing with black lung, where the employer must have fraudulently concealed or manipulated dust samples. I think if you conceal something, you're acting in fraud. But for some reason, they was hung up on that word. We had that battle yesterday. And you guys got that word back in there. Now, I got to say, throughout this debate until that became an issue. The West Virginia Coal Association's silence was deafening to me. They kind of stayed out of this until that happened. Then all of a sudden, text messages started going out. You guys got them, saying a deal was a deal. I didn't get one. I wonder why they didn't send me one. They said labor made a deal. Labor did not make a deal. They may have perceived there was a deal, but there was no deal. And it's disingenuous for them to send you guys those text messages. And they didn't send it to me because I probably would have come out here and said something about it on the floor. But what happened has worked. It's done what it was supposed to do. So why are we back? I think there's some bad actors out there that want some more protection. I think there's people who want more protection because they're not doing what they're supposed to do and providing a safe environment and workplace for their workers. It just bothers me to no end that we got to come in and deal with stuff like this when the solution's real simple. Just provide your employees a safe place to work. If there's a guard missing on the machine, put the damn guard back on. If the area's dusty, get in compliance. Put people before profits for a change. That's all you got to do. And when you do that, you won't be dealing with anything like this. And most of the places I worked complied. And I'm probably most of the places you guys own or worked at complied. I'm just not for protecting bad actors. If they would clean up their workplace and did everything they could to prevent accidents, we would not need laws like this. We wouldn't even be having this discussion. Mr. President, I'm sorry, I am not in agreement to anything that's happened here. I was not part of any deal or any discussions. I think this is a bad deal for workers. It's a bad deal for injured workers, and it's really a bad deal for surviving spouses when the worst of the worst happens. It just blows my mind that we're here taking care of people who don't want to take care of who creates their wealth. I'm a no. I'd encourage a no vote on this bill. Just sad day, Mr. President. Thank you.
Is there further discussion? Senator from Ohio.
Thank you, Mr. President. The senator from Marion did a very great job describing the problems with this bill, but I do want to touch on a few things. Deliberate intent is the worst of the worst cases. If there's mere negligence, an accident, workers' comp takes over. This is reckless, criminal, beyond unsafe, against industry standards that this deliberate intent law is there for. And I was walking the Capitol grounds late last night, working on some amendments to bills, and I met a lawyer. And he was a retired workers' compensation lawyer who worked for the government. And he heard me on the news, and he heard the senator from Marion on the news. And he said, we're absolutely right. He worked for workers' comp, and he knows that these cases are very few, and they're there to protect the people who are recklessly, criminally being put in danger. So I will be a no vote. I think that we've already done enough with the deliberate intent that has lowered premiums. It has lowered cases, and I just urge everybody else to vote no too.
Is there further discussion? If not, the question for the Senate is, shall the bill pass? All those in favor vote yea. Those opposed vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? If so, the clerk close the machine and ascertain the results. On this question, 24 yeas, 8 nays, 2 absent and not voting. More than a majority of those present voting having voted in the affirmative, I declare the bill passed. The clerk will communicate the action and send it to the House.
Engrossed committee substitute for House Bill 2436 relating to the implementation of an